The first is the whole cooperation between center and state, and that has been a massive, massive success. The second is the removal of cascade of taxes and the integration of multiple taxes. It's not an easy job, and to do it and bring down the impact on consumer price index and make sure that it's not inflationary by itself is massive. The third is the expansive basket of GST. GST, while it has certain exclusions, but it has covered most of the commodities. And the fourth is that there is a common regulation across the country. If you go back to VAT days, every state had their own laws, own complexities, own compliances. But now we have a common law across the country, which is a massive success. It has been a very dynamic situation. There have been a bunch of meetings, as you can see from the barometer of all the 47 meetings that have happened. The initial 25-30 meetings were with full consensus, and then you started seeing shades of disagreements and disputes and debates. But in the structure that has been designed under the Constitution, that is a welcome aspect. Right? Even the Supreme Court recently, in a judgment of Mohit Minerals, recognized that every state has their right to press taxation. They don't have to just follow what the GST Council says. So on the positive side, yes, there is a lot of debate, but it is resulting in full representation across the country. It's not only the center's mind that is driving the law. On the challenges side, clearly any sort of distortion that starts happening, especially now that the compensation window is over, and the same Supreme Court judgment says that state has an independent jurisdiction to tax. We are afraid that states may start changing rates at a state level, given the flexibility they have. The hope is that that won't happen, but there is a risk of distortion. For any taxpayer, the two elements of the framework that matter the most is the law itself, that if the law stays consistent across the country, you're able to, as an organization, implement it as one nation, one tax. You're able to have standard policies, procedures, technology, right? And second is the rates of tax. Now, we know the concept that existed in the olden days called MRP, and companies were compelled to determine one MRP based on differential tax rates across the country, some levying octroi, some levying other various taxes, which GST was able to eliminate, and a predictable tax regime was, or tax rate regime was available. If this, the previous comment that I made, if states start exercising flexibility on the rate front as well as on the law front, the concept of one nation, one tax will get challenged. And it is the responsibility of the GST Council to keep the pack together and make sure that all voices are heard and all aspects are covered in the combined law and the combined rate structure. The GOMs that are created on rate rationalization, for example, cuts across party lines. And I'm hopeful that with such structures, we will be able to make sure that these distortions are avoided. On the government strategy side, I think they are focused to make sure that all sets of taxpayers are getting sufficient attention. But yes, there is a need to enhance some aspects of the law. For example, the input tax regime that we follow, we still have a list of items on which you don't recover input credits. It increases the cost for everybody, including MSMEs. Second, you have a complexly worded law which creates the risk of litigation, debate, and all organizations, especially MSME, may not have the wherewithal to fight it in courts for multiple years to resolve issues. Third, if you look at the whole matching concept, that you have to match your credits and only then you will be allowed the credit, it puts both sides pressure on MSME. One, ensuring their vendors are compliant, and second, they should be compliant because they don't get paid from larger organizations. Because this compliance has now become real time, and the law has now been proposed to be changed to say that if your vendor does not pay the tax or does not report the transaction, your credits are in jeopardy. It is the direction in which the law has evolved or is evolving will negatively impact smaller businesses, and therefore there is definitely a need for rationalizing the input tax credit regime. And finally, I would say on the powers of the tax officer, Supreme Court has time and again suggested that the power to arrest or apprehend people should be used sparingly and should be used only after a detailed show cause notice is issued. We are seeing several instances of this power being used much in advance at the time of investigation. While in case of fake invoicing and tax evasion, maybe that is the right thing to get discipline in place. But it again creates a risk of threat of abuse of power, and smaller organizations are more impacted by such provisions. So there is a need to even relook at how these powers are being used. In fact, Vivek Jory made a statement yesterday, who's the CBIC chairman, that they are going to come up with guidelines on how investigation should be conducted and what are the powers and how should they be used. The advent of GST expected taxpayers to leapfrog from a month-end reporting to a transaction-by-transaction reporting. And that has been a challenge for small, medium, and large, all sorts of companies. Because initially compliance was complex, people were still up the learning curve, and the first 3 to 4 years have been a matter of debate. The law and circulars have given sufficient leeway to suggest that credits can be taken based on books. But on ground, the way it's getting implemented is causing some challenges and disruption, where there is an expectation that if you are not able to match transactions, you are going to reverse your input tax credits. And as you rightly pointed out, there was very limited window to correct transactions. You are unable to correct past transactions now, and that is stopping people from recording it and presenting it correctly. In my opinion, the first 4 to 5 years should be treated as a special case, especially before implementation of e-invoicing, at least till September 2020. All those transactions should be respected the way they are based on document-based credit, the logic that was followed in excise and VAT and service tax in the past. And then only with e-invoicing, where more real-time qualitative data is available, the matching principles should be enforced. And the sooner we drop the e-invoicing thresholds to 5 crores as it is projected, you will have a very large majority of transactions getting reported real time on an accurate basis, which will automatically clean up some of these problems.